Alrighty, class. Welcome back to the wonderful world of business law. We are going to focus in on criminal law. Criminal law, of course, differs from civil law. In civil actions, plaintiffs seek compensation or other remedies for themselves, but crimes involve the state. This is because crimes involve a harm to society, although harm to society is not always evident in the act itself, is what the text says. This means that the harm might seem like it was specifically done perhaps to one person. If someone comes up and does battery to me, someone comes up to me, punches me in the stomach, it might seem that, was that really harm to society? That was just harm to Dan. But allowing these types of actions to take place without there being some type of punishment that comes involved lets others, of course, think that they can get away with battery, and then, of course, you can then begin to see how this is a harm to society. Actus reus and mens reus. A crime consists of an act, that is actus reus. This is Latin. It means that crimes require some type of action. Mens rea means guilty mind. Guilty mind is the mental intent, the mens rea. It's the intent to cause the act to have happened. So criminal law is divided up into the actus reus, the mens rea, the action, and the mental intent, the guilty mind. To commit a crime requires actus rea. It always requires an action in order for a crime to occur. The mens rea requirement depends on the nature of the crime. Crimes are usually defined by statute and constitute an offense against society. True? Felonies and misdemeanors. A felony is a crime usually punishable by more than 1 year of imprisonment or death. Typically, this is going to be murder, rape, kidnapping, armed robbery, etc. Other crimes are going to be known as misdemeanors, petty offenses, or infractions. Offenses against the person. Homicide. There are, of course, excuses, self-defense being one of those. Homicide is going to be divided up into levels of how bad was the homicide, how awful to society was the homicide, and then the greater punishment that the homicide deserves. The most severely punished form is going to be what is typically called murder, which is malice aforethought, which is talking about intent. This is one of the homicide is one of my favorite ways to really divide up into the actus rea and the mens rea. The actus rea here is the act of the homicide. That's going to be the action. But then the mens rea, the intent involved in the homicide is going to equate to the greater or lesser punishment that the homicide occurs. So the most severe form of punishment is going to be the malice aforethought. That is going to be where the defendant had intent to kill. Intent to kill with malice aforethought might seem like it requires a lot of planning. This is going to be a matter of state law, but typically it requires a lesser degree of planning. It might be the bar fight, where I get into a fight and I decide to pull out my knife and stab the other person. I'm in a bar fight. I didn't have a whole lot of time to think about killing the other person, but I went ahead and said, yep, I want to kill this other person. I'm going to grab my knife and I'm going to stab them. I'm doing it on purpose. That is intent. That's malice aforethought. Highest degree of murder. The felony murder rule. This is a consequence of an armed robbery. In an armed robbery, where there's multiple individuals taking part in the armed robbery, if one of them kills another person, then they're all going to be tried underneath the malice aforethought for that murder. Voluntary manslaughter is an intentional killing, but one carried out in the sudden heat of passion as a result of some provocation. A great one here is you come home from a long day of work and you find your partner cheating on you, and you fly into a fit of rage and kill your partner and whoever they were with. Potentially voluntary manslaughter. It was an intentional killing, but it was carried out in the sudden heat of passion. Involuntary manslaughter, this is going to be one of the lesser degrees of willfulness, and this occurs where someone has taken on a reckless action that results in death. So typically this was an accident, a mistake, not thinking through your actions well and causing death as a result. Offenses against the person. We're moving on to assault and battery. Assault and battery here, it's important to note, is different than the assault and battery in tort law. Torts is the next chapter, but it's important, just I think at this point, to even just let you know ahead of time, there's assault and battery in the criminal realm, and there's assault and battery in the civil realm, which is called a tort. Here we're talking about assault and battery in the criminal perspective. Assault, let's start off with battery. Battery is the unlawful application of force to another person. Now, this, of course, doesn't apply to all acts of physical force. For instance, a hockey player who injures another person during a hockey game in a manner that's going to occur in a hockey game is not going to be prosecuted for the crime of battery. But still, battery is the unlawful application of force. So battery requires actually contact of force to another person. This is separate from assault, even though we often say assault and battery together. These are actually two separate things. Assault is going to be the attempt to commit a battery or the deliberate placing of another in fear of receiving a battery. So if you throw a rock at someone and they manage to dodge it, you committed assault. You attempted to commit the battery, but you did not. Or you could just intimidate them and fake them. You could pretend like you're going to throw the rock, but not. But the other person becomes apprehensive of the fact that an immediate battery could occur. True or false, homicide is the killing of another person. True. Criminal assault is the unlawful application of force to another person. Remember, assault is the thinking that a battery is going to occur, that force is going to happen, that it's going to be applied, but it is not. Assault is where the unlawful application of force does not occur. So this would be false. This would be true if it was criminal battery is the unlawful application of force to another person. That is true. Criminal assault is the apprehension or the cause for concern or the intimidation of or the attempted battery but you missed. So we're moving away from crimes against people, and now we're coming to crimes against property. Larceny, taking away and carrying of personal property of another with the intent to steal the same. This is fantastic old legal language right here. If you read this, you can see many loopholes in this language, but it's a great example. This is a fine example for the class of what the theft of larceny is, but remember, this is going to be a state law thing. States are going to have different definitions for larceny, but just to talk about this older style definition of larceny, when we're breaking this into components or elements in order to prove that this happened, we have taking and carrying away of personal property of another with intent to steal the same. So perhaps if I'm at an airport and I have my black bag and I'm sitting beside someone else with a identical looking black bag, and I get up and I accidentally grab their bag instead of mine and walk away, but I did it on accident, would that qualify? Well, yeah, it would, because I did actually intend to take the bag and carry it away as mine. Now, intent to steal, maybe you'd have some wiggle room there, but you can see how this definition can accidentally carry with it some scenarios that one wouldn't typically think would be the theft of larceny. In addition, because it specifically says personal property, there's another example on here about a man walking through an orchard and plucks a peach from a tree and eats it. That person would not be guilty of larceny because he's not taking away personal property, because peach is part of a land being connected to a tree, and therefore, off of a legal definition, a peach would be trespass to land or some type of damage to land, but would not be larceny. In addition, sneaking into a movie theater without paying is not an act of larceny, although in many states it might be, or it's in some type of other criminal definition, right? You're doing something wrong there, whether it's trespass or whatever in the criminal realm, but it would not equal this particular definition we have in the text for larceny. Robbery is defined as larceny from a person by means of violence or intimidation. Embezzlement is the difference between larceny, where you never really had legal possession of the item when you had intent to steal it, but embezzlement, you have someone who has legal possession or illegal, for instance, like an employee with a checkbook, that type of thing. They have some legal rights to be doing what they're doing, but then they abscond and are improper with that money and steal it then for their own use. But at first they had a right to be handling that money, perhaps due to their employee duties, that type of thing, but then they abscond with it at that point. So then the law creates a difference between larceny and embezzlement. False pretenses. False pretenses is obtaining property of another by making untrue representations with an intent to defraud. It's important here that it says intent to defraud. So if you would borrow money from another person, you do actually intend to repay them, then that is not going to be false pretenses. But if you are bringing false financial information to another to show them that you're wealthy, or you have this business plan, or you own these business assets, or whatever, some type of thing that you've fabricated in order to entice someone to loan you money, now we're moving into the realm of false pretenses. You're intending to steal money from another by creating some lies to induce that person to loan you money. Receiving stolen property requires some amount of knowledge. Knowledge, though, is construed broadly. It's not mere actual knowledge, but the correct belief and suspicion strong enough not to investigate for fear the property will turn out to be stolen are sufficient for conviction. So states are going to treat this differently, but there's a question in regard to knowledge. How much did you know when you received the property that it was stolen? Forgery, again, requires intent to defraud, similar to false pretenses. Extortion used to require government officials, but now it's been broadened. extortion is typically called blackmail. The false writing of a document of legal significance with an intent to defraud is extortion. That would be false. It would be forgery. Offenses against a person's habitation. Here we have burglary. Again, this is a little bit of an example of a more archaic definition of burglary, but we have the breaking and entering of the dwelling of another in the nighttime with the intent to commit felony. So here you can already see some huge loopholes in this type of language. Nighttime, burglary requires nighttime, so you're telling me you can't burgle a place in the daytime. Also, it requires breaking and entering. So do I literally need to break something? What if they accidentally left their door open? What if I manage to pick a lock so that I'm not breaking the door? What if I never enter? What if I use a rope or something and throw it in and hook something out? What if at the time when I went in, I didn't intend to commit the felony, but then once I was inside, I'm like, hey, now I'll commit a felony. So, pretty terrible language in regards to a burglary, but you get the point. Arson, old language there was it required a malicious burning of the dwelling of another, a dwelling being considered a home, but now we know, of course, arsony can be more than just homes. It can be business, etc. Bribery is corrupt payment. Perjury is the crime of giving a false oath. White-collar crime. Although white-collar crime is going to be a typical bit of terminology that's used, you're not going to usually find that in a statute or in a law. It is a category that we've created inside of our legal studies in order to divide or group up laws in regards to studying them. So what are called white-collar crimes? They're distinguished from street crime. Typically, white-collar crime are going to be fraudulent related acts carried out in a non-violent way, usually connected with a business. So armed robbery, not a white-collar crime, but embezzlement, which we already went through above, by a teller or a bank officer would be a white-collar crime. So embezzlement, false pretenses, those are going to be your typical ones. In addition, many white-collar crimes are going to be statutory crimes, labeling and identifying certain different types of activities as a crime. So here we have tax fraud, price fixing, violations of food, drug, and environmental laws, corporate bribery, etc., the newest form, computer fraud. Mail and wire fraud, violations of the Food and Drug Act, environmental crimes. There's going to be different levels of intent required for these crimes. Usually, you're going to have a lesser degree of intent required. Breaking and entering of the dwelling of another in the nighttime with intent to commit a felony is a burglary. Violations of the Foreign Corrupt Practices Act. Racketeering Influenced in Corrupt Organizations Act, otherwise known as RICO. RICO is very broad in order to prosecute many different types of wrongdoing. This is a question involving a bribe. Go ahead and pause, take a read, take your best guess. Bribery occurs when the person accepts the bribe. Whenever the person you're bribing accepts it, that's when the bribe occurs. So it's the third option there. Computer crime. Computer crime falls into those four listed categories. You can see the variety of lengths of punishments there, depending on the actions. Criminal offenses can be committed against what types of things? It's going to be all three of those things. Environmental crimes are handled exclusively by. This is going to be a trick question. You would want to pick the EPA, I think would be likely your intuition, but environmental crimes are going to be handled by a variety of different departments, state, federal, regulatory agencies. Just because the EPA has the ability to promulgate laws in regards to environmental protection doesn't stop the city of Dayton from having their own laws in regards to dumping or trash or toxins in the water or something like that. So environmental crimes are not handled exclusively by anybody. The nature of a criminal act. To be guilty of a crime, you must have acted. Right, the mental desire or intent to do so is insufficient. So we do have attempt. An attempt to commit the crime is punishable as well, though usually not as severely. Although we've got some exclusions here, actual impossibility. What if a defendant is accused of attempting a crime that is factually impossible? The mens rea or criminal intent was there, but the act itself was not criminal. An example there would be you intend to poison someone, you have your poison already, you go and you put it in their drink, you give them their goblet, they drink their goblet, they don't die, but you put the poison in there, but later you figure out that it was actually like vitamins or medicine or whatever. You just messed it up. You grabbed the wrong thing. So even though you intended to kill them, you thought that you did it, you did the act, you had the intent, but you failed to do so. Will that be considered attempt and you'll have a lesser degree of punishment, or whether that will not be considered attempt because you had the intention, you did the act, you had the intent, whether or not you'll just be tried as if you committed homicide will depend on state law. Legal impossibility is different and is usually acknowledged as a valid offense. If the defendant completes all of their intended acts, but those acts do not fulfill all the required elements of a crime, there could be a successful impossibility. Conspiracies. Conspiracies are an agreement, so it requires more than one person, and and to be part of the conspiracy, you have to at least do a single overt act in furtherance of the conspiracy. So, for instance, if I agree to help rob a bank, and I'm supposed to be the getaway driver, just the fact that I agreed to be part of the robbery doesn't mean that the conspiracy has occurred yet. It requires a single overt act. So if I've said I'm going to be the getaway driver, and I go and I purchase a getaway vehicle, or I rent the getaway vehicle, then I have done an overt act in furtherance of the conspiracy. So we've got the agreement and the act. Once you're part of the conspiracy, the act of any one of the conspirators is imputed to the other, which is a bad thing, meaning that if I'm the getaway driver and there's an armed robbery that I'm part of the conspirators with that, and then one of my co-conspirators kills someone, then even though I'm a getaway driver in the vehicle and not even in there as part of the armed robbery, I can be tried for that highest level of manslaughter, that homicide as well. Excuses. Mistake of law. Ordinarily, ignorance of the law is not an excuse. Exceptions can be made when you've gotten bad advice. If this bad advice was from a government official or your attorney, potentially then you can have a mistake of law in regards to ignorance of the law. Mistake of fact. Ignorance or mistake of fact more frequently will serve as an excuse. So, if you take a coat from a restaurant believing it to be yours, you cannot be convicted of larceny because of mistake of fact. You didn't intend to steal that person's coat. You thought it was your own coat, therefore, not larceny. Entrapment. Police are permitted to use techniques to detect criminal activity. They can set up stings and busts, and they can have undercover police, that type of thing. That's fine. If the police can provide an opportunity to commit a criminal act, the sale of drugs by an undercover agent, for example, as long as it's part of an ongoing detection of a criminal activity, they are not permitted to do so to instigate a crime. So a good example of entrapment would be if a police officer dresses up undercover and just randomly walks around to all different people's houses and says, "Hey, you want to buy some heroin? I've got some heroin right here." A random person who opened their door, "Would you like to buy some heroin?" That's entrapment. There was no ongoing criminal activity or investigation or that kind of thing, and they just randomly go to different people's houses and just see, "Hey, who wants to buy some heroin?" and then arrest those people. That would be entrapment. Other potential excuses for committing crimes would be compulsion, right? You're forced to do it, gun pointed to your head. Honest consent of the victim, the quarterback who's tackled, right? It's a sporting event, so some consent there. Adherence to requirements of legitimate public authority, lawfully exercised, right? Like a policeman directing a towing company or move a car, that type of thing. Proper exercise of domestic authority, right? A parent may spank a child within limits, that type of thing. Self-defense, defense of property, that kind of thing. Of course, there's some limitations to defense of property, right? You can't set booby traps to kill someone to protect your car, something like that. But each, as I'm getting into quid pro quos here, at the end of the list, I have each of these excuses as a complex subject in and of itself. Could be chapters within a law book. Lack of capacity. Infants and children are generally considered incapable of committing a crime. Under the age of 7 is the amount given in the textbook. Insanity can be a defense. Intoxication can be a defense, but the mere fact of drunkenness is not ordinarily sufficient. Procedure. So we have this criminal act that has occurred. What happens after that? Typically, the first thing that's going to happen is the arrest / the warrant for the arrest. The arrest is made. You have the defendant in custody. There's going to be a preliminary hearing. The purpose of the hearing is, I shouldn't say defendant, I should say perhaps accused. Yes, accused is the right terminology. The preliminary hearing. The purpose of the hearing is to determine whether there's sufficient reason to hold the accused for trial and set bail or not, of course, depending on flight risk. The prosecution must either file an information, which is a document stating the crime of which the person is being held is being accused of, or ask the grand jury for an indictment. The indictment is the grand jury's formal declaration of charges on which the accused will be tried. If indicted, the accused formally becomes a defendant at that point. So at first, the arrest, the warrant, preliminary hearing, the person is an accused. After the document has been filed or the grand jury indictment has been done, that's when they've been formally accused and becomes a defendant. The defendant will then be arraigned, which means they are brought before a judge to answer the accusation of the indictment. They can either plead guilty or not guilty. If they plead not guilty, the case will be tried, perhaps before a jury. The jury cannot convict unless they find the defendant guilty beyond a reasonable doubt. Beyond a reasonable doubt. That's the burden of proof upon the prosecution. Plea bargaining. The defendant might have pleaded to the offense or to a lesser charge. The plea of nolo contendere, or the plea of no contest, neither affirms nor denies guilt. What the heck is a no contest plea? A no contest plea means you're pleading guilty, but this is going to be as a result of a plea bargain, but you're not admitting that you actually did the act. You're pleading guilty, but you're not admitting that you actually did it. Well, what the heck is the difference? And the difference really is civil liability. If you plead guilty and then someone also ends up suing you civilly for whatever you did, and you might have some civil damages you're worried about, pleading guilty, saying you did the act, might make it easier for the person in the civil court to meet their burdens of proof and be successful to you in the civil action, and you'll be required also to pay civil damages along with being punished criminally. If you plea no contest, you're not admitting that you actually did it, but you're accepting this lower plea bargaining arrangement and saying and not agreeing that you specifically did the act. Therefore, the person in the civil court trying to sue you there for damages are going to have to go ahead and work from the ground up and can't use a guilty plea against you. Of course, following the guilty plea or the plea of no contest, the judge will impose a sentence. The judge typically has some ability to choose whether or not you're going to have imprisonment, a fine, or both, a suspended sentence, parole, community actions, or some other things they might require the defendant to do. Which of the following best defines a grand jury? And it's going to be this fourth one is going to be the correct answer. A grand jury is not finding guilt. What they're looking for, it's a group of citizens that hear the state evidence and determines whether there's reasonable basis, probable cause exists for believing that a crime has been committed and thus that a criminal proceeding should be brought against a defendant. They're not determining guilt at that point. What must a prosecutor prove to find a defendant guilty of a crime? It's actus reus and mens rea. Remember, there has to be an action, and then there has to be intent. There has to be a guilty mind, unless the law would say otherwise. If the law says otherwise, that intent is not required, then intent would not be required. But the law does need to address whether or not mens rea needs to be present. Constitutional rights of the accused. Double jeopardy. Fifth Amendment prohibits a person from being prosecuted twice for the same offense. That's in the criminal realm. Remember, civil is different. So if I would commit manslaughter and kill someone, I can be suffer criminal punishment, but then civilly I can be sued as well for damages done clearly to that person, their estate, their family, etc. So then I would owe damages to the family, which is typically going to be monetary damages, and then the criminal is going to be some type of punishment in the criminal realm. Criminal and civil results are separate. That is not double jeopardy. Self-incrimination. The Fifth Amendment is the source of a person's right against self-incrimination. You can't be compelled to be a witness against yourself. And flowing from that as well is forced confessions and Miranda warnings. Miranda warnings are required. You obviously cannot force a confession from accused. Speedy trial. The Sixth Amendment tells the government they must try defendants quickly. Cross-examination. The Sixth Amendment allows defendants the right to confront their witnesses. Back in the day, hundreds of years ago, perhaps you'd be locked up in some criminal jail cell, and the trial would occur, and you wouldn't even be brought forth, and evidence would be brought against you, and you'd be kept in your cell, and you would not even know who was accusing you or what type of testimony they were giving. So clearly, the ability to confront your witnesses against you is great. Assistance of counsel. Sixth Amendment, here again. Of course, the law is complex. Just everything that I went through might be astounding to you, the complexities that we have in just this one chapter of business law. Cruel and unusual punishment. Not allowed. Presumption of innocence. This is the origin of beyond all reasonable doubt is the standard of proof. Fifth Amendment requires due process. 14th Amendment requires each state to provide due process. Defendants are innocent until proven guilty. Is that the most important constitutional right in the U.S. criminal justice system? And it's true. Presumption of innocence is the most important constitutional right. Presumption of innocence is a constitutional protection under the Fifth Amendment. Fifth and 14th Amendment. All right, everyone. Thanks again for listening to the presentation. Best of luck in your studies. Thank you for your hard work, and have a good night. Peace out.